Senator Blumenthal.
Thanks, Mr. Chairman. I will be interested in hearing how 702 has been useful with respect to both Ukraine and China. I can certainly understand as to China. I wonder if you could give us a little bit more, even in this public setting, about how it's been important to our assistance to Ukraine in its fight against Russia's criminal, murderous aggression.
Senator, let me take a shot at that, but mindful that I do think that some of the real substance would be better discussed in closed session. And so what I will say, and picking up a little bit on the answer to the prior question, is that our adversaries, whether they're Russians, Chinese, Iranians, North Koreans, terrorist organizations, make use of U.S. communications service providers. And if there is a reason for believing that we have some foreigner operating overseas who is using a communication service that is provided by a U.S. service provider, we, or more likely the NSA, will target that foreign person overseas to collect the intelligence collect those communications. We can then query the database of information that is collected on those foreign persons overseas. We run queries, NSA runs queries, obviously FBI runs queries against this database of information that is collected when it is reasonably likely to retrieve foreign intelligence information. And we do that in the Ukraine context, we do that in the context of the People's Republic of China, and in other contexts where we have national security.
And in the Ukraine context, we can play a part in supporting Ukraine through sharing our intelligence, correct?
There's a whole host of ways in which we're supporting the Ukrainian government with intelligence sharing, and it involves the full swath of collection that the United States is involved in.
Let me ask you, as you may know, and I think we've talked about it in our conversations in my office, I've been a longtime advocate of some more robust adversarial process within the Section 702 FISA procedure. In 2015, Congress took an important step in codifying the Amicus responsibility. My numbers are from 2015 to 2020, there were 1,200 FISA applications, but just 19 Amicus appointments. And in 2017, the only amicus at the time with significant criminal defense experience in the FISA context resigned because he hadn't been assigned to a single case. Those numbers tell me that the present amicus process is not providing really robust or sufficient adversarial procedure, when we all know as lawyers that our justice system thrives on the adversarial procedure. This area is the one part of our justice system where we have no such adversarial process because the subjects of 702 collection likely will never learn that they've been the subject of this process. So what is your position on this issue? I think I know what it is, but I'd like you to state it for the record, if you would, sir.
Senator, is that a question for Mr. Olson or for me?
Whoever would like to answer.
Why don't I turn it over to Mr. Olson, who
I'm
handles
happy to answer that
litigation.
question, Senator. I represent lead the National Security Division. We represent the government before the Foreign Intelligence Surveillance Court, so we're directly involved in the process that you described. First, we are open to reforms, as I said at the beginning, that preserve the essential effectiveness of Section 702. So if there are reforms, for example, to the FISA court process, we're happy to engage with you and other members of Congress as we think through how those would work. When it comes to the amicus process, the FISA court can ask for an amicus to be appointed in any case. And they do so in any case involving a novel or complex interpretation of FISA. And that's the cases that are the hard cases, where they do have an adversarial process through the amicus appointment. The vast majority of FISA applications are basically the same as the ex parte process that occurs in a Title III criminal application, which is not an adversarial process, but rather criminal.
It's not, but eventually there is likely to be a challenge.
That's correct.
And in this instance, there's likely to be no challenge. And so the privacy interests arise not only where there's some new, major, novel interpretation of law, but as you well know, you know a lot more than I do at least, the case-by-case decisions often turn on interpretations of law that are challengeable. And that's why an adversarial process would provide a lot of reassurance, I think, to this committee and the American people.
Again, we're open to having this conversation and engaging with you on this. It is my view that the vast majority of FISA applications are basically facts against the probable cause standard. They don't involve novel interpretations of the law, and they are done on a level of with a degree of urgency, multiple times a week, that does not lend itself to the sort of adversarial back and forth process that an amicus would introduce, and so there's some serious risk to having, for example, an amicus in every case.
Thank you.
Thank you, Senator Blumenthal. Senator Lee?
Over the past 12 and a half years, I've raised significant